The legal system of the Republic of the Union of Myanmar. Introduction. The Republic of the Union of Myanmar, formerly known as Burma, is a sovereign state in Southeast Asia that borders Bangladesh, India, China, Laos, and Thailand. Its coastline extends from the Bay of Bengal to the Andaman Sea between Bangladesh and Thailand. It has a total of 261,227 square miles of territory, which approximately consists of 152,319 square miles land territory and 8,907 square miles coastline. Myanmar is constituted by 7 regions as well as states and a union territory. The society of Myanmar is multi-ethnic as well as multi-religious in nature, and Burmese is the official language. Politically, until January 31, 2021, the country used to practice a multi-party democratic system. Its legislative, executive, and judicial powers were separated for the purpose of reciprocal control, check and balance among themselves. These 3 branches of sovereign power are constitutionally shared among the Union Territory, regions, states, and semi-self-administered areas. Section 11, the 2008 Constitution. February 1, 2021, when the Myanmar military overthrew the democratically elected government and detained the state councillor Aung San Suu Kyi along with other elected leaders. The peace-loving and democracy-craved ordinary citizens and some civil servants refused to accept these military moves and started to protest using different modes and mediums. Such activities of the protesters made the military regime furious, resulting in the use of unnecessary, disproportionate, and lethal forces in the name of protection of public safety and security and control of civil disobedience. The spokesperson of the United Nations High Commissioner for Human Rights briefed that as a consequence of the protest demonstration after this military coup, hundreds of people have been killed, many have been received arrest warrants, thousands have been detained, some have been prosecuted secretly, while some other unfortunate have received death sentences, and there is no sign to end to these brutal crackdowns. Additionally, thousands of civil servants, nearly 70% of women and workers in the education sector have been dismissed, removed, or suspended from their jobs. As a result, the future political direction of the country is currently uncertain. A brief legal history. During the reign of monarchy before British occupation, Myanmar was ruled by absolute monarch, and thus king held supreme power in the executive, legislative, and judiciary. In the executive function, the king was the highest authority, assisted by ministers, mayors, townships, village headmen, and government servants. The sole legislative power was vested to the king, and he was assisted by the parliament. The king was also the highest authority in the judiciary and assisted by the supreme queen, crown prince, princess, as well as ministers in the parliament. Leto. Judges appointed by the king, mayors, townships, and village headmen. In ancient times, the practice of trial by ordeal was common, and most critical punishments were fines. There were only 4 types of crimes punished by the death penalty, that is murder, rebellion, insurgency, and rape. The beginning of the former judicial system in Myanmar can be traced back to the epoch of the Bagan dynasty. Bagan dynasty, that is 849 to 1287 AD. There were 3 primary sources of law, namely Yajadet, Dhammadet, and Phaito. Yajadet refers to the king's royal edicts and ordinances, which are composed of the king's commands and criminal laws. Dhammadet is derived from the Hindu Dharmashastra, treatise on law, which was later reformed as Myanmar customary law. Fiat Ashtun means the judicial decisions made by the Lutu and various benches and courts in the country. During the British occupation in 1886, the British established the Court of Judicial Commissioner for Upper Myanmar in Mandala. The Court of the Lower Myanmar was established in 1990 as the highest appeal court. In 1922, the High Court of Judicature of Yangon was established after the abolishment of the aforesaid two judicial organs. Subdivision courts, district civil and session courts, township courts were also established with specific jurisdiction. The British also introduced several crimes several criminals as well as civil laws, including the Indian Penal Code 1860, Criminal Procedure Code 1862, Indian Evidence Act 1872, and Civil Procedure Code 1859. After independence, even after gaining its independence on January 4 of 1984, Myanmar continues to apply the common law legal system as its basis. The Supreme Court, High Court, and other subordinate courts are established at different levels under the Union Judiciary Act of 1948. The Supreme Court was the highest court as well as the final appeal court throughout the Union, and its decisions were binding over all other courts. In 1962, the Revolutionary Council abolished the former judicial system and formed the Chief Court to be in the line with socialism. In 1974, it further introduced a new constitution under which the Central Court, State and Divisional Courts, Township Courts, and Wards and Village Tracts Courts were established. In 1988, the State Law and Order Restoration Council enacted the judiciary law to transform the aforesaid socialist judicial system. The Supreme Court and High Court were re-established in the same year. In 2000, this was again repealed by the judiciary law by the State Peace and Development Council in transforming the formation of courts. Lastly, in 2010, the Union of Myanmar, the Union Judiciary Law was enacted to adopt the current judicial system under the 208 Constitution. The Brigham Center for the Rule of Law developed a constitutional awareness booklet containing the key provisions of current Myanmar Constitution and relevant areas in a simple manner. Executive organ. The government of Myanmar is basically formed with the President, Vice President, Ministers of the Union, and Attorney General of the Union. Section 20, the 2008 Constitution. The executive power of the Union is distributed among the Union, regions, states, and self-administered areas as prescribed by the Constitution. The executive head is the President, who takes precedence over all other persons throughout the Union. Section 58, 199, the 2008 Constitution. The President may appoint as well as dismiss the ministries of the Union government and designate the member of the Union ministers as necessary with the approval of the Baiduangshu Lato, Section 2002, 232, 233, 234, and 235 of the 2008 Constitution. He may further appoint the Attorney General of the Union to seek legal advice and assign duties on legal matters with the approval of the Baiduangshu Lato and the Deputy Attorney General to assist the Attorney General, Section 237 and 239 of the 2008 Constitution. The region and state governments are formed respectively with the Chief Minister of the region or state, the ministers of the region or state, and the Advocate General of the region or state, Section 248A and B, the 2008 Constitution. Generally, this region or state government have the responsibility to assist the union government in preserving the stability, peace, tranquility, and prevalence of law and order of the Union, Section 250, the 2008 Constitution. The president appoints a Lato representative and the chief minister of the region or state concerned with the approval of the respective region or state, Lato. Section 261C, the 2008 Constitution. To understand the state and region government in Myanmar, see the region or state government law 2018. See the Asia Foundation's report on state and region governments in Myanmar to understand the substantial government institutions and central local relations. The administrative body of the self-administered division or self-administered zone is called the leading body, section 275 of the 2008 Constitution, which is comprised of at least 10 members, section 276C, the 2008 Constitution. The president must appoint the person who is nominated as the chairperson of the self-administered division or zone concerned, section 276F, 2008 Constitution. As per the administration of the Napier-Tau Union Territory, the president must form a Napier-Tau Council and appoint a person who have the qualifications prescribed in the 2008 Constitution as chairman as well as members of Napier-Tau Council. Section 284 and 285 of the 2008 Constitution. So far, 5 self-administered zones have been established in Naga, Pao, Paluang, Kokang, and Wa. Myanmar's National League for Democracy, NLD, Aung San Suu Kyi's political party, won a landslide victory in the 2015 Myanmar general election. The post of state councillor was created on April 6, 2016 for Aung San Suu Kyi to allow her to play the greater role within the government of Myanmar, because the 2008 Constitution, which was written by the former military rulers and also guarantees the army a 25% block of state seats, prevents her from becoming the president of Myanmar, as her husband and her 2 children hold foreign nationality. The state councillor bill calling for the appointment of Aung San Suu Kyi by name as the state councillor includes 5 chapters and 8 articles, and it gives her the right to contact government ministers, departments, organizations, associations, and individuals for counsel. She is also accountable for her duty to the Union Parliament. The term of the office of the councillor is 5 years, which is the same as that of the president. The bill is aimed at ensuring a multi-party democratic system, a market-oriented economic system, and a federal union, peace and development in the country. Part 2 of the Myanmar oil and gas sector-wide impact assessment report developed by the Myanmar Center for Responsible Business contains a discussion on the government structure and legal framework. Legislative system. The legislative authority is based in the Phaya Duangsu Lato, the national parliament, which comprises of 2 Latos, namely the Paitu Lato, the People's Assembly or House of Representatives, and the Amota Lato, the National Assembly or Senate. Section 74, the 2008 Constitution. Pidangshu Lato makes laws, authorizes the government to spend public money, scrutinizes government activities, and is a forum for debate on national issue. The Phaya Lato is formed with a maximum of 440 seats and comprises of no more than 330 representatives elected on the basis of the township as well as population, and no more than 110 representatives who are the defense service personnel nominated by the Commander-in-Chief of the Defense Services. Section 109, the 2008 Constitution. The Amota Lato is formed with a maximum of 224 seats, comprised of 168 representatives elected in equal members from regions as well as states, and 56 representatives who are the defense service personnel nominated by the Commander-in-Chief of the Defense Services. Section 141, the 2008 Constitution. The Supreme Court of the Union. The Supreme Court is the highest court of the Union without prejudice to the jurisdiction of the Constitutional Tribunal and the Courts Martial, Section 294, the 2008 Constitution. It is the apex of the court system in Myanmar, which exists as an independent body alongside the legislative and executive branches. The court is situated in Napier Atoll and headed by the Chief Justice of the Union. It may be appointed from a minimum of 7 and a maximum of 11 judges of the Supreme Court, including the Chief Justice, Section 299A and B, the 2008 Constitution. The President may appoint the Chief Justice and judges of the Supreme Court after seeking approval from the Pidyangshu Lato, which has no right to refuse the person nominated by the President for the appointment unless it can clearly be proved that the person do not meet the qualification for the post. Section 299C and D, the 2008 Constitution. The Supreme Court has original jurisdiction in matters arising out of bilateral treaties concluded by the Union. It disputes except constitutional issues between the Union government and the region or state governments, and among the regions, among states, between the region and state, and between Union territory and region or state. Piracy and other offenses committed at the ground or international water or airspace by violating international law and in other matters as prescribed by the law, by any law. Section 295A, the 2008 Constitution, Section 11 of the Union Judiciary Law 2010. It has the appellate jurisdiction to decide judgments passed by the high courts of the regions or the states and judgments passed by other courts in accord with the law. Section 295D, 2008 Constitution. Section 12, the Union Judiciary Law 2010. It also has the revisionary power over any judgment or order passed by any subordinate court. Section 295E, 2008 Constitution. Section 13, the Union Judiciary Law 2010, and the jurisdiction on confirming death sentence as well as appeal against death sentence. Section 14, the Union Judiciary Law 2010. It further has the jurisdiction to transfer a case from a court to itself or any other court. Section 15, the Union Judiciary Law 2010. It possesses the power to issue a writ of habeas corpus, writ of mandamus, writ of prohibition, writ of warranto, and writ of certiorari. However, this power to issue writ is suspended in the areas where the state of emergency is declared. Section 296, the 2008 Constitution. Section 16, the Union Judiciary Law 2010 also said this. The decision of the Supreme Court is final and as well as conclusive, and thus it is the final court of appeal in the entire Union. Section 295D, B and C, the 2008 Constitution. Section 18 and 22, the Union Judiciary Law 2010. High Court of the region and High Courts of the state. A High Court is established for every region and the state of the Union. Section 305, the 2008 Constitution. Each High Court is headed by a Chief Justice, a minimum of 3 and a maximum of 7 judges, including the Chief Justice, may be appointed. Section 308A, 2008 Constitution. The President can appoint the Chief Justice and the judges of a High Court in coordination with the Chief Justice of the Union as well as the Chief Minister of the respective region or state after seeking approval from the respective region or state. Lato, which has no right to refuse the person nominated by the President for the appointment unless it can clearly be proved that the person do not meet the qualification for the post. Section 308B, the 2008 Constitution. Every High Court of region or state has jurisdiction to adjudicate on the original case, appeal case, revision case, and other matters prescribed by any law. Section 308, 2008 Constitution. Section 38, the Union Judiciary Law 2010. It also has appellate jurisdiction on the judgments, decrees, orders passed by all other subordinate courts. Section 39, the Union Judiciary Law 2010. It also has the power to supervise district courts as well as township courts in the region or state, and courts of self-administered divisions as well as courts of self-administered zones if there are self-administered areas in the region or state, section 314 2008 Constitution. It further has the jurisdiction to transfer a case from a court to itself or to any other court within its respective region or state, section 40 the Union Judiciary Law 2010. It has unlimited jurisdiction to hear and decide both criminal and civil suits. District courts, courts of the self-administered division, and courts of self-administered zone. District courts, courts of self-administered division, and courts of self-administered zone have the jurisdiction to hear both criminal as well as civil cases, appeal cases, revisional cases, and other matters prescribed by any law. Section 315 2008 Constitution. Section 53 and 54 of the Union Judiciary Law 2010. The respective High Court of the region or state supervises the appointment of judges at the level of courts. Section 308A, the 2008 Constitution. Judges at this level are granted the right to try serious criminal cases and civil suits not exceeding 500 million kyats under original jurisdiction. Township courts have the jurisdiction to try both criminal as well as civil cases and other matters prescribed by any law, section 316 2008 Constitution, section 56 the Union Judiciary Law 2010. The respective High Court of the region or state supervises the appointment of judges at this level of courts, section 318A the 2008 Constitution. These levels of courts are mainly courts of original jurisdiction. Judges at this level can pass a sentence or up to 7 years imprisonment. They can try civil suits in which the amount in dispute or value of the subject matter is not exceeding 10 million kyats. They also exercise jurisdiction over juvenile cases. Courts martial. The courts martial are established under the 2008 Constitution in order to adjudicate defense service personnel. Section 319 of the 2008 Constitution. Read Human Rights Watch and Al Jazeera news articles related to Myanmar's court martial. The Constitutional Tribunal of the Union. The Constitutional Tribunal of the Union is formed with 9 members, 3 members chosen by the President, 3 members chosen by the Speaker of Piangtu Lotu, Paitu Lotu, and 3 members chosen by the Speaker of Amota Lotu. The 1 member from among 9 members is assisted as the chairperson. Section 320, 321, the 2008 Constitution. Its essential function are to interpret the provisions under the Constitution, decide constitutional disputes in the Union, and review whether the laws promulgated are in conformity with the Constitution. Section 322, the 2008 Constitution. The President can appoint the chairperson and its members after seeking approval from Pidangshu Lotu, which has no right to refuse the persons nominated by the President for the appointment unless it can clearly be proved that they are disqualified for the post. Section 327, 328, 2008 Constitution. The President, the Speaker of Pidangshu Lotu, the Speaker of Pitu Lotu, and the Speaker of Amota Lotu, the Chief Justice of the Union, and the Chairperson of the Union Election Commission have the right to submit any constitutional matter to the Constitutional Tribunal and seek for the interpretation, resolution, and opinion. Section 325, the 2008 Constitution. Besides, the Chief Minister of the region or state, the Speaker of the region or state, Lotu, and the Chairperson of the Self-Administered Division or Self-Administered Zone leading body and representatives membering at least 10% of all the representatives of the Piangtu Lotu or the Amota Lotu may also have the right to submit constitutional matters to the Constitutional Tribunal in accordance with the prescribed procedure and obtain the interpretation, resolution, and opinion. Section 326, the 2008 Constitution. A court that submits any case involving constitutional issue to the Constitutional Tribunal in accordance with the prescribed procedures for its opinion must stay in the trial until it receives such a resolution. In addition, its resolution is final and conclusive. Section 323, the 2008 Constitution. Other courts. There are also other courts with specific jurisdiction, namely juvenile courts to try offences committed by minors, municipal courts to try municipal offences, and motor vehicle courts to try road traffic offences. In terms of hierarchy, township courts and other courts are courts of the first instance, district courts, courts of the self-administered divisions, and courts of self-administered zone are courts of the first appeal. The High Court of the regions and states are courts of the second appeal, and the Supreme Court is the court of final appeal. Source of law. Source of law in Myanmar comprises of constitutions, parliament enacted legislation, common law and English common law, customary law and English common law. English common law rules developed and adopted in Myanmar case law during the British occupation are applied where there is an absence of local legislation governing a particular matter before the court. Moreover, judges are granted discretionary power to decide the matter in accordance with justice, equity, and good conscience in the absence of any applicable law. Any law, rule, regulation, or bylaw passed by the Pidangshu Latu and signed by the President or deemed to have been signed are published in the Myanmar Naingan Pentan Myanmar Gazette. The Gazette is published by the News and Periodicals Enterprise (PNPE) under the Ministry of Information of Myanmar. Among all decided cases from the superior courts, some are selected by the Conjoint Selection Board, which comprises of judges from the Supreme Court of the Union and Deputy Attorney General as well as Director General from the Union Attorney General's Office in order to be published in the annual law report published by the Supreme Court of the Union. Cases decided by the Supreme Court of the Union are published on its official website. The Burma Code is a collection of Myanmar's law enacted and in force from the year 1939 to 1951. The code is combination of 13 volumes, volume 1 to 13, covering the list of legislation enacted since the British colonial period. The general year-wise index to the Burma Code is also available. Legal profession. Legal professionals comprise of judges, judicial officers, and lawyers. Lawyers can be classified into two types, namely advocates and pleaders. An advocate is entitled to appear before any court and tribunal in the Union, whereas a pleader is licensed to practice only before subordinate courts. Pleaders are subdivided into further categories: ordinary pleader, who handle criminal matters and low-level civil disputes, and higher grade pleaders, and higher grade pleaders who can take on all types of cases. Criminal prosecutions are conducted by law officers based in regional offices all over the country. All are subject to the direction of the Attorney General, whose powers and duties are described in Attorney General of the Union Law of 2010. Legal practitioners are governed by the Legal Practitioners Act 1879 and the Bar Council Act 1926. Legal education. Universities of Myanmar offer a degree of Bachelor of Laws, LLB, 5-year program, degree of Masters of Law, LLM, 2-year program, degree of Masters of Research, MRes, 1-year program, and degree of Doctor of Philosophy, PhD, 5-year program. Myanmar and international law. Myanmar's legal system is predominantly influenced by the common law system since it was under the British colony for more than 100 years. The common law system was originated in the United Kingdom, that is usually referred to as the mother of common law countries. As far as the application of international law in the democratic legal system is concerned, the common law countries practice in dualist in nature, where Myanmar is one of such countries. According to Article 38(1) of the Statutes of the International Court of Justice, there are two primary sources of international law, that is, international treaties and customary law. For dualist countries, international law, particularly treaties, are not directly applicable domestically. The legislative body or the parliament must implement international law by passing domestic legislation in order for the international treaty to have a domestic effect. However, there may be situations where customary international law principles such as the jus cogens norms can be automatically applied in the domestic legal context even without the enactment of any parliamentary legislation. Myanmar is a party to several multilateral treaties, including the UN Charter and human rights treaties, such as the Convention on the Elimination of All Forms of Discrimination against Women, the International Covenant on Economic, Social and Cultural Rights, the Convention on the Rights of the Child, and the optional protocols, and the Genocide Convention. Thank you, viewers, for watching. I am Shamim. This article is taken from www.nayodlawglobal.org.